have all gathered here to discuss, to deliberate on how to improve the enforcement of the Community Court of Court judgments. All I will say is, as we depart, my fellow delegates, my fellow participants, as we depart, we should always remember the deliberations we had here, the recommendations that has been made and adopted, and try as much as possible to ensure we implement it. It's the only way to enthrone rule of law within the ECOWAS region. So I thank everyone, the press, the interpreters, and those that were in the kitchen that made everything good for all of us. As a matter of fact, I think we were fondled like babies. So as we depart, may all of us get back to our destinations in one piece, the way we came. And as we are leaving also, may we try, I said it yesterday, to find some little time still remaining and enter Lagos so that Lagos will know that you visited it. Don't just stay in the hotel and then go back. This is Lagos. This is Lagos. Thank you very much, and God bless.
I wish you all safe travels back, and may our collaboration for justice continue to guide our work in the years to come. We would also like to extend our thanks to the interpreters, to the rapporteurs, whose work in a timely manner has been capital. To the Director of Finance, to the press also for your excellent coverage, as well as to the protocol services and all persons who have contributed to the success of this. Thank you all for your attention, and God bless us all.
As to what the court does and how judgments of the court are enforced. If you were here the first day, you would find out. And of course, if you've been reading the papers recently, we were in Lagos a few weeks ago. I recognized some faces. And we know one of the issues highlighted as being the main challenge, or main challenges we face with, is the issue of enforcement. Yeah. So just to say, ECOWAS now has 12 member states. I don't need to list the states. We're in Nigeria, just to say the headquarters of ECOWAS is Nigeria. The court too is headquartered in Nigeria. And the court, the law providing for the court, the treaty on the court, was first put in place in 1991. We know the Treaty of Lagos was adopted in 1975. And if you look at Article 4 of that treaty, what was called the ECOWAS Tribunal was listed as one of the institutions of the community. But we know in 1993 that treaty was revised. For those of us who are students of history, we know in the early 90s, late 80s, 90s, we lived in a very troubled region, you know, civil war in Liberia, civil war in Freetown, you know, hundreds of people killed. So the politicians then deciding, even though this was meant to be an economic union, it is important we also start looking into human rights issues, which is why, if you look at the revised treaty of 1993, the protection of human and people's rights is identified as one of the fundamental principles of the community. You know, you can't talk about a good business environment when people's rights are not respected. So, like I said, the treaty revised in 1993, and if you look at Article 6 of the revised treaty, sorry if I sound like a lawyer section article, but I just want us to understand. The court again is listed as one of the institutions of the community. But even before the treaty was revised, in 1991, a treaty on the court was put in place. The 1991 treaty was silent. It just provided for the court, how judges are appointed, etc. But it had no information on how judgments of the court should be enforced. And again, what was meant to be created in 1991 was a court that will settle disputes between member states. In other words, there was no place for individuals, you know. But like I said, with the disturbances in some of our countries, in 2005, our leaders decided to adopt a supplementary protocol that is called the 2005 Supplementary Protocol, making amendments to the 1991 treaty. And the 2005 Supplementary Protocol, which was adopted in January 2005, for the first time ever, gave the court a human rights mandate, giving the court the power to preside over human rights cases. Not only did that treaty do that, it also allowed individuals and NGOs direct access to the court. Remember, I said in the 91 treaty, it was about Nigeria maybe taking Benin to court. There was no place for individuals. So that changed in 2005. So you also would see, even though the treaty was put in place in 91, the first judges appointed in 2001, the ECOWAS Court did not have a case until 3 years later. You know, African governments are not fond of suing each other. So it was when the law was amended in 2005 to give the court a human rights mandate and also to allow individuals access, that was when the court started having cases. So with me, like as we speak, majority of the cases dealt with by the court. Some would say maybe more than even 90% of the cases dealt with by the court are human rights cases. I hope that is clear. So now, when we talk about the jurisdiction of the court, we have it grouped into 4 broad categories. First, we say it's a community court, meaning, you know, in our sub-region, we have adopted so many treaties on democracy, elections, on freedom of movement, etc. So if anybody wants those treaties interpreted or applied, the proper place to go to is the court. It's a community court, interpreting application of treaties. That's first. Second, we say the court serves as an arbitral tribunal. The 2005 protocol, if you look at the revised treaty, it says, the 1993 revised treaty, it talks about ECOWAS having an arbitration tribunal. But in 2005, the new law they brought in says, pending the time an arbitration tribunal is set up for ECOWAS, the court would serve as the arbitration tribunal for the community. So apart from being a community court, it is also the court of arbitration for the community. But that has not kick-started yet, because we're working on getting the rules of procedure for the arbitration tribunal finalized. Probably by this time next year that will start. Thirdly, we also say it's a public service court. If you work for ECOWAS, like you work for the ECOWAS Commission, you work for the ECOWAS Court, you have an employment dispute. The Commission and the court have diplomatic protection. So you cannot drag the court before a court in Nigeria because of that diplomacy thing, like diplomatic status. So what you do as an employee of any ECOWAS institution, if you are aggrieved, probably you feel your boss has been maltreating you, your boss has not been fair to you, you have an issue you think you can take to court. The proper place to go to is the ECOWAS Court, Public Service Court. It could be employment disputes against institutions of the community. By institutions, I'm talking about the court itself. If, as a registrar, I feel the court hasn't treated me fairly, nothing can stop me from suing the court. Or you work for the agency on money laundering, against money laundering in Dakar, Djibouti. You have a problem as an employee. You run to Abuja. You work for Parliament, the ECOWAS Parliament, employment dispute, the proper place to go to is the court. So that's the third. The fourth, which is the most important, I shouldn't say the most important, but majority of the cases we deal with relate to the fourth, which is the court's human rights mandate, like a human rights court. So we say it's a community court, it is a public service court, it is also an arbitration tribunal. Most importantly, it is a human rights court. What is important about the court's human rights mandate? It's an international court. So one would have expected, if you have a problem as a Nigerian, before you run to the international court, at least you will try to do something about it at the local level, as in insisting you need to exhaust local remedies. But that's not a principle applicable to the ECOWAS Court. When your rights are violated, you are Senegalese, you are Nigerian, you are from Guinea-Bissau, you are from Cote d'Ivoire, whenever you feel your rights have been violated, under the law, you can run to the ECOWAS Court to seek redress. So which means you don't need to exhaust local remedies. You can go to the ECOWAS Court straight. And since the doors were opened in 2005, the court has dealt with more than 400 cases. For Nigeria, I went through the statistics yesterday. It has dealt with a total of about 145, as in maybe I shouldn't say cases. It has delivered a total of 125 judgments relating to Nigeria. I wouldn't say judgments against Nigeria. The judgments related to Nigeria in the sense some of them involve instances where the cases filed were dismissed. So as we speak, the total number of judgments relevant to Nigeria are 125. So I hope that background is good enough for you. Now, why are we here? If you look at the treaty I talked about, the 2005, which made it possible for human rights cases to be submitted to the court, which also made it possible for individuals and NGOs to file cases before the court. There is a particular article, 24, very important. You can Google, get all this information online. That article provides for how judgments of the court should be enforced. What does it say? First, it requires all member states of ECOWAS to appoint the competent authority that is responsible for enforcing the judgments of the court. Nigeria, appoint somebody who is responsible. Guinea-Bissau, you have to do so. The Gambia, you have to do so. Senegal, you have to do so. As I speak, 10 member states have already done that. 10. So we only have 2 member states that have not yet done that. Why is this important? You are Nigerian, you go to the court, you argue your case, you win your case. It wouldn't be helpful for you to run around looking for who to engage when it comes to enforcement. So like you might say, this is an international court, maybe I should go to the Ministry of Foreign Affairs. Or maybe ECOWAS is about trade, maybe I should go to the Ministry of Trade. Or the judgment is about money, maybe I should go to the Ministry of Finance. But, oh, this is a legal matter, maybe I should go to the Attorney General. So then, like I said, the treaty made it simple. in the sense it is telling us that Nigeria is required to appoint the authority, and Nigeria has done so. Actually, Nigeria was the first country to do so in June 2011. That's about 14 years ago. And the appointed authority for Nigeria is the Attorney General of the Federation and Minister of Justice. That's the appointed authority. For most countries, like I said, 10 countries have done so. For most of the 10 countries, just like Nigeria, the authority appointed is the Ministry of Justice. Guinea appointed the Chief Registrar of the Supreme Court of Guinea. Cote d'Ivoire appointed what they call Procureur General of the Court of Appeal of Abidjan. Guinea-Bissau appointed a directorate in the Ministry of Justice. But for Togo, Gambia, Senegal, and of course Ghana, all of them appointed their ministers of justice as the competent authority. So now that it's clear, how does it work? When the court delivers a judgment, going by the law, it is supposed to send what is called a writ of execution. Like, for example, let's say we're saying Lekon versus Nigeria. The case is heard. The court orders Nigeria to pay Lekon compensation of $10,000. What we expect from Lekon, what the court would do after judgment, is to prepare a writ which is addressed to the Minister of Justice of the Federation, stating the orders of the court and further requesting the Justice Minister to go ahead and enforce the judgment. The law says, or the treaty says, you enforce in accordance with the rules of procedure of your country. So meaning, you send it to the authority in the Gambia, send it to the authority in Togo, send it to the authority in Nigeria, and what you want is for them to enforce the judgment using the rules of civil procedure of Nigeria. So meaning latitude given to the states. Gambia would use their own, Nigeria would use their own. And when the competent authority gets the writ of execution, the authority is meant to confirm, verify, is this truly from the court? Of course, it bears the court stamp, the chief registrar's signature. And it then goes ahead to enforce and then report back to the court on measures taken. That is how it works. We don't have an international military or international police that will go around telling states, if you do not do this, we'll close your border or we'll arrest you. That's not how it works. So clearly from what I said, a lot of it depends on political will. Yeah, so that's the law. Those are the procedures. Very, very, very clear. But we have had challenges getting judgments enforced. Our statistics tell us the enforcement rate is about 20 to 22%. 22 to 22%. But one thing I want to explain, this is not just unique to the ECOWAS Court. Last year, I was at a meeting in Kenya, and we had people from the African Court complaining. Maybe theirs may be probably not as good as ours because they're talking about their enforcement rate being below 10%. And if you do your research, I talked about it in my paper yesterday, we are made to understand even the European Court, which has been around much longer, they have more than 6,000 judgments that have not been enforced. I'm not saying just because others are not doing as good, we cannot do better. You know, it's our court, we have to support it. And I don't think people would continue coming to the court if at the end of the day they feel, I mean, what I get is a paper tiger judgment that really has not meant anything to me. Yeah, but one thing I also want to say before I shut up is pleading with us not to confuse enforcement not to confuse the statistics I just mentioned with impact. The two are different. I don't think there is anybody in West Africa who would say, even if the enforcement was as great as 1%, who would say the court has had zero impact. Recently, I mean, like about a year or maybe even less than a year ago, the court made an order that Nigeria should amend Section 24 of its cybercrime law. And we made to understand that has happened from the communications received. So you can imagine the kind of impact changing that particular law would have on Nigerians. And because it's a regional court, the impact can be felt even outside of Nigeria. It can inspire advocates, for example, in the Gambia, when they think Gambia is operating a similar law. I hope you understand. And in a place like where I come from, Gambia, we lived in a period until about 2016 where we had a military ruler. Many journalists were forced into exile, meaning it wasn't possible for you to challenge the government openly before the courts. So what did our people do? So many victims ran to the ECOWAS Court, and some of the cases filed included journalists who were killed, some included journalists who were disappeared. Until now, some we don't know where they are. So, which means at a time when it was impossible or difficult for Gambians whose rights were violated to go anywhere, the only avenue available was the ECOWAS Court. And why I also think the court is important, the kind of impact it might have. You all are Nigerian. You don't have to be a lawyer to know in Nigeria we have what we call Chapter 2 of Nigeria's Constitution, which we say provides for directive principles of state policy. You cannot go to court in Nigeria and maybe say my right to education is violated, my right to health is violated. But the ECOWAS Court does not make that distinction. For as long as it is a right provided for in a treaty Nigeria has ratified, the court will apply it. So meaning you might have your door shut in Nigeria in the sense the right you're claiming might be called unjusticiable. But at the end of the day, if you go to the ECOWAS Court, what it looks for is whether the right is in a treaty ratified by Nigeria. It's not about whether we call it a first generation right, second generation or third generation. So I think it's also important to take note of that. Like I said, enforcement might be low. We're doing our best to make sure there are improvements. But at the end of the day, that doesn't mean the court hasn't served any purpose. And why are we here? I talked about the competent authorities. All 10 have appointed competent authorities. So what we want to do is have an annual meeting in which these competent authorities would meet with the court so that we can brainstorm together as to what to do to improve the low rate we just talked about earlier on. Like maybe Senegal can learn from Nigeria. Nigeria can learn from Benin. We try to identify common challenges and then try to come up with a roadmap as to how we address them. So we have come up with recommendations, and we're going to come up with a table on how we go about enforcing the recommendations, and we'll be giving ourselves deadlines. And we're planning on having this at least once a year. So maybe when we have it in Nigeria, if we are to have it next year, it might not be in Nigeria, it might not be in a member state. Like, let's speak to each other. Let's find out what the issues are. Let's find out what areas we need to improve. You know, we are the same community. We are the same people. We have set up a court for us. Let's support the court. It is facing XY's challenge. Let's try to address the challenge. That's what we are here for, trying to learn from each other, trying to come up with a roadmap on how we can make things better at the court, particularly the enforcement of its judgments. Thank you.